move about. Hopefully you won't be doing much moving, but the doors won't be locked at that point. So if you have any issues sitting, this is now the time to excuse yourself. Thank you. You ready?
Yes, ma'am.
Stay here?
Yeah.
Okay. Brandon. Officer Murphy, you can lock the door.
Somebody went to the restaurant. I just heard. I just told everybody was ready. That one person ran to the
There's
restaurant.
always one person. Yeah, tell them to come on in now.
Ready, huh?
Yes.
Jury's now entering into the courtroom. They like to eat that.
You guys had a big lunch. Y'all stay away.
Take one, pass it down. Take one, pass it down, please.
Are there any family or anybody over here, as far as you know, out there, Officer Murphy? Okay. Those of you who just joined us in the audience, I am preparing to read the jury charge. It's lengthy. It's going to take me about 15 minutes or so to read it. If you're going to have difficulty sitting still during this time, I ask you to excuse yourself now. You're welcome to come back in once the lawyers start their closing arguments. But there will be no movement during this time while I read the instructions to the jury. The doors will be locked. There won't be any in and out. So this is the next part to this. This is my instructions to you. The law requires that I read this to you. I don't want to insult anybody's intelligence. I believe everybody can read, but the law does require that you hear it all at the same time. So I must read it all to you. Okay? State of Tennessee versus Hernandez Govan. Members of the jury, the evidence in the case has been completed and it is now my duty to instruct you as to the law. After I instruct you as to the law, the state and the defense may present their closing arguments. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Ladies and gentlemen, the copy that you have there is for your use, so feel free to mark it up as you please. Duties of the court and jury. The law makes it the duty of the court to charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them in the trial and under the law given them by the court, render their verdicts with absolute impartiality. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdicts. You must render your verdicts with absolute fairness and impartiality as you think justice and truth dictate. Formal charge, not evidence. The indictment in this case is the formal written accusation charging the defendant with the crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made, do I mean to indicate any opinion as to the facts or as to what your verdicts should be. Statements and arguments of counsel. Statements, arguments, and remarks of attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statement were made by the attorneys in this trial at any time that you believe are not supported by the evidence, you should disregard them. Along these lines, the opening and closing arguments of the attorneys are likewise not evidence. You must base your decision in this case on the evidence that was actually presented in this court, not on these statements of attorneys. Furthermore, the questions the lawyers ask the witnesses are not evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is true. Jury, judges of facts and law. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding the case. You should consider all of the evidence in light of your own observations and experiences in life. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. And this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element necessary to constitute the offense. Crimes charged and plea. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within this offense is the lesser included offenses of facilitation to wit conspiracy to commit first-degree murder, solicitation to wit conspiracy to commit first-degree murder, accessory after the fact to wit conspiracy to commit first-degree murder. The second count of the indictment charges the offense. The second count of the indictment charges the offense of first-degree murder. Embraced and included within this offense are the lesser included offenses of second-degree murder, facilitation to wit first-degree murder, solicitation to wit first-degree murder, facilitation to wit second-degree murder, solicitation to wit second-degree murder, aggravated assault, facilitation to wit aggravated assault, solicitation to wit aggravated assault, accessory after the fact to wit first-degree murder, assault. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find a defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of the conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. Facilitation to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation to wit, conspiracy to commit first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific felony of facilitation to wit, conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of first-degree murder, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on pages 4 and 5 for you. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation, to wit, conspiracy to commit first-degree murder. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find the defendant guilty of solicitation, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of conspiracy to commit first-degree murder, with the intent that the offense of conspiracy to commit first-degree murder be committed. Intentionally, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Accessory, after the fact, to wit, conspiracy to commit first-degree murder. Any person who commits the offense of accessory after the fact is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew or had reasonable grounds to believe that Justin Johnson and Cornelius Smith committed first-degree murder, a felony, and that the defendant acted with the intent to hinder the arrest, trial, conviction, or punishment of Justin Johnson and Cornelius Smith, and that the defendant provided or aided in providing Justin Johnson and Cornelius Smith with any means of avoiding arrest, trial, conviction, or punishment. Knowing means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 2 in the indictment. First-degree murder. A person who commits the offense of first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intention to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Facilitation to wit, first-degree murder. Any person who commits the offense of facilitation to wit, first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific felony of first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or the results of the offense, and that the defendant furnished substantial assistance to that person in the commission of first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder is previously defined on page 10. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, second-degree murder. Any person who commits the offense of facilitation to wit, second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific felony of second-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of second-degree murder, and that the defendant furnished such assistance knowingly. Second-degree murder is previously defined on page 11. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation to wit, first-degree murder. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find a defendant guilty of solicitation to wit, first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of first-degree murder with the intent that the offense of first-degree murder be committed. Intentionally, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Solicitation to wit, second-degree murder. A person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find the defendant guilty of solicitation to wit, second-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of second-degree murder with the intent that the offense of second-degree murder be committed. Intentionally, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, aggravated assault. Any person who commits the offense of facilitation to wit, aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of first-degree murder, and that the defendant furnished such assistance knowingly. Aggravated assault has been previously defined on page 15. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Solicitation to wit, aggravated assault. Any person who solicits or attempts to solicit another to commit an offense is guilty of a crime. For you to find a defendant guilty of solicitation to wit, aggravated assault, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant, by means of oral, written, electronic communication, directly or through another, intentionally commanded, requested, hired another to commit the offense of aggravated assault with the intent that the offense of aggravated assault be committed. Intentionally, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Accessory after the fact to wit, first-degree murder. Any person who commits the offense of accessory after the fact is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew or had reasonable grounds to believe that Justin Johnson and Cornelius Smith committed first-degree murder, a felony, that the defendant acted with the intent to hinder the arrest, trial, conviction, or punishment of Justin Johnson and Cornelius Smith, and that the defendant provided or aided in providing Justin Johnson and Cornelius Smith with any means of avoiding arrest, trial, conviction, or punishment. Knowing means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to another, and that the defendant acted intentionally, knowingly, or recklessly. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. The defendant has pleaded not guilty to each and every offense charged and included in the indictment. Direct and circumstantial evidence. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which gives you clues about what happens in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. The defendant may be convicted on direct evidence, circumstantial evidence, or both. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. To find the defendant criminally responsible for the act of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Before you find the defendant guilty of being criminally responsible for the said offense committed by the conduct of another, you must find that all the essential elements of said offense have been proven by the state beyond a reasonable doubt. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all of the evidence presented in this case by the state and by the defendant and give it a full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them, if you can. For the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard? Whether the witness's statements were consistent and how believable the statements were. Whether the witness had a motive to testify truthfully or to testify untruthfully. And any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all of the evidence in the case? Another factor for you to consider in evaluating a witness's testimony is whether the witness has made material statements at some point before he or she testified which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Expert witness. During the trial, you heard the expert testimony of Dr. Juliet Scantleberry, who was described as an expert in the field of forensic pathology. You also heard the expert testimony of Lieutenant Michael Coburn, who was described as an expert in the field of crime scene analysis. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact in issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. In giving her opinion, Dr. Scantlebury testified that she took into consideration certain statements made by other persons. Because the statements were made outside the courtroom, they may be used by you only for evaluating the expert witness's opinion testimony and cannot be relied upon as proof of the truth of the matter asserted in those statements. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept that opinion. The same as with any other witness. It is up to you to decide whether you believe the testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Stipulations. A stipulation is an agreement between the parties. The parties have stipulated in 3 situations that certain matters of fact are true. They are bound by these agreements, and in your considerations of the evidence, you are to treat these facts as proved. The parties have entered into 3 different stipulations. The first stipulation was entered as Exhibit 17. The parties have agreed that the phone number 901-859-1460 belonged to Hernandez Govan. The second stipulation was entered as Exhibit number 24. The parties have agreed that phone number 901-618-3848 belonged to Hernandez Govan. The third stipulation was entered as Collective Exhibit number 33. The parties have agreed to enter into evidence certain sound bites played and testified to by witnesses Angela Arnold, Cornelius Smith, and Detective Jesse Brown. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view of reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effects of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. These are my instructions to you. We are now ready for closing arguments.
Good afternoon.
Good afternoon.
So earlier this week, you heard me talk about choices. And I warned you, you would hear a lot of evidence, you would hear a lot of voices, you would see a lot of footage, hear a lot of names. But I also told you, if you'll remember, that the name that you needed to focus on and the name that you needed to remember is Hernandez Govan. But most importantly, I told you needed to focus on the consequences of his choices. Hernandez Govan and the consequences of his choices. And the consequences. What were those consequences? Violence, death, and loss. And not just the violent death of a famous music artist, but the violent death of a human being, a person, someone whose life was marked with artistry, community, entrepreneurship. So let's take one last look at how that life ended. A life, ladies and gentlemen. But before I get into how much we've heard this week and what exactly we've heard this week, let's talk about the law, and let's talk about what the judge instructed you. Conspiracy to commit first-degree murder. That's the first count. In order for there to be a conspiracy to commit first-degree murder, there has to be four things. There has to be an agreement with one or more people to commit the offense of first-degree murder. There has to be, or number two, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acting for the purpose of promoting or facilitating the commission of the offense of the first-degree murder agreed that one or more of them would engage in the conduct which constitutes the first-degree murder. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. The two important things about this charge is an agreement and an overt act. And in the jury instructions, you heard that an overt act is done by one or more of the parties in order to carry out the intent of the conspiracy. And it must be a step toward the execution of the conspiracy. In first-degree murder cases, often enough, the overt act is the murder. Count number 2, first-degree murder. A definition of first-degree murder is the premeditated killing of another. Number 1, someone unlawfully killed the victim. 2, they acted intentionally. And 3, the killing was premeditated. You heard in the jury instruction that in order for there to be intent, there has to be a conscious objective or a desire. You also heard about criminal responsibility. Criminal responsibility, that basically means that you don't have to be the person that pulls the trigger in order to be responsible for the first-degree murder. The jury instructions say that criminal responsibility is when someone acts with the intent to promote or assist the commission of the offense or to benefit from the proceeds or results of the offense. The defendant acts, solicits, directs, aids, or attempts to aid another person to commit the offense. Further, they don't have to be present when the offense is taking place. Encouragement of the offense is enough. So let's talk about what we heard this week. We heard first from Erica Thornton. She told you that she is the victim's sister. They were close. And the last time that she saw him was on FaceTime. The next thing she hears that her brother was taken from her. She told you about the person that she knew, the brother that she had, and the life that was lost. A life, ladies and gentlemen. We also heard from Raul Hopkins. He told you that he had been employed with Mr. Thornton for years as his security. He explained to you the tension between PRE and CMG. And he explained to you that CMG wanted Thornton to sign with them, but he didn't. And because of that, there's been tension. He talked about diss tracks. He talked about various acts of violence committed on Thornton. And he told you about CMG and their connections. Well, as you've heard from the testimony this week, Hernandez Govan is affiliated with CMG. He has connections within CMG. CMG was in direct conflict with Thornton and the life and the legacy that he built. Govan had an in with CMG. Govan had a direct conflict with the life and the legacy that Thornton built. And then you heard from Cornelius Smith. And that's where it got interesting. He told you that he met Govan in 2021 through a friend named Bobby Carter. The relationship started out as transactional. Cornelius Smith had a pill problem. Govan provided the pills. But then one day, Govan asks him if he wants to make some money. Smith told you that, of course, he has a drug problem. He has 5 kids. He needed money. So, of course, he wants to make money. And he tells you about several discussions between Govan, himself, Justin Johnson, and Jook. He tells you that at one of those meetings, Govan told him that there were multiple bounties on PRE artists, including Mr. Thornton, but also Paper Route Wu. He told you that on one night, he was given guns by Govan. He was given guns by Govan to attempt a hit on Paper Route Wu. He told you that out of the multiple bounties on PRE artists, Thornton's was the highest. Thornton's was $100,000. So of course he jumped on the opportunity. And Smith told on himself. He told you everything. He told you chapter and verse, who was in the room and what was said. And if you're thinking about a conspiracy, who would you want to hear from the most? A co-conspirator. Someone that is in the room, someone who can tell you what happened, what was agreed to, what went on. So after he found out about what this bounty was, he talked about November. He talked about how him and Justin knew about a turkey drive that PRE hosts every November. He told you that there were a few days where they went hunting. They knew that there was going to be multiple days where the turkey drives were happening. On the 16th, him and Justin Johnson went out hunting. Wasn't successful. On the 17th, he told you that Justin picked him up from his father's house. He told you that when he picked him up from his father's house, Smith and Johnson went hunting again. And when they were at the intersection of Lamar and Airways, they saw Dolph's car drive past. Earlier this week, I told you that most Memphians know Adolph Thornton's car when they see it. And Cornelius Smith told you the same thing. They knew who it was when he drove past. So they followed the car. They followed the car all the way to Makita's, and at Makita's, they pulled around, parked the white Mercedes that they were in, got out, gunned down Adolph Thornton, and killed him. They got back in the white Mercedes, and they left, but not before Marcus Thornton shot Cornelius Smith. Smith also told you that they ditched the car. He told you that they ditched the car on Bradley Street, across the street from the defendant's home. He told you that once they left the car there, they went to 2-Lane Apartments. At 2-Lane Apartments, that's where they switched clothes, that's where they had their wound kits, and that's where Cornelius realized that he left his phone. He left his phone and he needed a ride. So he used his co-conspirator's phone, Justin Johnson, to contact his girlfriend to pick him up. And you heard that from Angela Arnold too. She told you that she got some communication from a phone number that she did not recognize. A phone number that was not her boyfriend's. It was not Cornelius's. He told her to pick her up, and she did. When she picked him up, he got inside the car. He told her that he had been hit. He told her what happened. And he told her that they killed Dolph. You also heard from Angela that he had previously told her that there was a hit on PRE artists, but she didn't believe him. But he told her. And he told her that there was a bounty. And when she picked him up that day, she learned that they had killed Dolph. They both testified that after they left the 2-lane apartments, they went to a gas station for Cornelius to buy some cigarettes. And after they left that gas station, they met up with Govan. They met up at the Pressure World. And at the Pressure World, Cornelius said that he got his phone back, and he got out the car. Well, first he got out the car. Then he went and talked to Govan, who was already outside the car. And he got his phone back and got back inside of Angela Arnold's car. Angela Arnold also testified that the same thing happened. She's never been to Pressure World before. She's driven past, but on this particular day, she pulled in. Cornelius got outside the car. Govan was waiting for him, and they went to the back and they talked. She didn't hear anything, but she saw the defendant there. And she knew that Cornelius had to get his phone. But then, Angela tells us, and she confirms what Cornelius already told you, that they had to get a car cover. She didn't know who the order came from, but she knew that they had to get a car cover. And Cornelius testified that he got the cash from Govan to get a car cover. So that's where they went. They got the car cover. But if you remember, Angela Arnold told us that there was some point where she dropped Cornelius off on Bradley Street for him to wipe down the car. She made a loop, she came back and she picked him up. Cornelius told you the same thing. He told you that he wiped down the car. One piece of information given by 2 different people saying the same thing. And then, if we're going back to what Cornelius told you, he told you that shortly before he was arrested, he ran into Hernandez Govan in the street. They parked their cars, they talked. Govan was worried that Smith didn't get any money. He told Smith, I'm gonna go to Prito. I'm gonna make sure you get your money. Well, of course he wanted to make sure that Cornelius got his money because he had previously asked for a $10,000 cut. He wanted his money too. Angela Arnold told you the same thing. She told you that Cornelius told her about this meeting in the street. She told you that Govan told Cornelius that he was going to go get his money. Cornelius told you that on the day that he was arrested, he was buying cake and ice cream for his daughter on her birthday. He told you how he got arrested. And Angela Arnold told you the same thing. One story, 2 people who told you the same thing. And we also heard from Sergeant Dabney. He was the case officer. He testified that he and other officers found the white Mercedes in the back of 1174 Bradley, directly across the street from the defendant's home. He told you, or he described the description of the car. He went through slide by slide, picture by picture, and told you that this was the white Mercedes that was used in the homicide to kill Adolph Thornton Jr. And then we got to Sergeant Browning. He went back to August 13th. He told you about an attempted shooting or attempted murder on someone named Paper Route Wu. And remember, Cornelius already told you that Govan told him that there were multiple bounties on PRE artists, including Paper Route Wu, also known as Terrence Baker. On this date, 911 dispatch received multiple calls about shots being fired in the area of 3645 Allendale Road. This is the shooting that Cornelius was talking about. The shooting that happened because of the guns that Govan provided. And on this day, there were multiple calls from Hernandez Govan to Justin Johnson, another one of the conspirators. 12 calls, or 12 communications, between Hernandez Govan and Justin Johnson on the day of the Paper Route Woo shooting. 8 calls, or 8 communications between Hernandez Govan and Cornelius Smith on the date of this Paper Route Woo shooting. 4 calls between Hernandez Govan and Anthony Mims, otherwise known as Big Joke, the number 2 person at CMG, on the day of the Paper Route Woo shooting. And then we get to November. We're going to talk about the conspirator communications. Defense will have you believe that there was no communication between Hernandez Govan and the rest of the conspirators. Sergeant Browning testified that on November 2nd, 2021, there were 7 communications between Justin Johnson and the number for Hernandez Govan. On November 3rd, 7 communications between Justin Johnson and Hernandez Govan. 20 communications between Cornelius Smith and Hernandez Govan. On November 4th, 7 communications between Justin Johnson and Hernandez Govan. 2 communications between Cornelius Smith and Hernandez Govan. On November 5th, 1 communication between Justin Johnson and Hernandez Govan. 4 communications between Cornelius Smith and Hernandez Govan. And as we get closer to the murder, November 6th, 4 communications between Cornelius Smith and Hernandez Govan. November 12th, 5 communications between Cornelius Smith and Hernandez Govan. November 15th, 2 days before the homicide, 2 communications between Cornelius Smith and Hernandez Govan. You heard it from defense that there was hardly any communication between Hernandez Govan and the conspirators immediately prior to the murder. But you see here that there was communication. November 17th, the day of the homicide. On this day, 17 communications between Hernandez Govan and Cornelius Smith, the person he chose to do a job. On November 17th, the day of the homicide, 15 communications between Justin Johnson and Hernandez Govan, the person Govan chose to do this job. And 3 communications from another number of Hernandez Govan, ending in 1460. Another thing about these call records is that it confirmed a lot of what Cornelius Smith told us. Cornelius Smith told us that he left his phone in the car on the day of the homicide. Well, the call records show that there are no outgoing communications from 12:04 hours to 14:36 hours, which would coincide with Cornelius Smith not having access to his phone during that time because he left it in the white Mercedes. These are surveillance footage that we've previously seen. Cornelius Smith told you chapter and verse that it was him and Justin Johnson that did this. He told you they entered into an agreement He told you that the reason they entered into the agreement was because of the $100,000 bounty. These records show that Cornelius didn't have his phone. He told you that he needed Justin Johnson's phone to contact Angela. And he said that he used Justin Johnson's phone, as indicated by the records. This shows that an outgoing communication from Justin Johnson's phone to Angela Arnold's phone, given the address of the two-lane apartments. And then he told you that he needed to get his phone back. Well, whose phone did he use? There's an outgoing communication from Angela Arnold's phone saying, "This Zebra, send me bruh number so I can get my phone," to Justin Johnson. And then they asked for Quez's number. And shortly after these text messages were sent, Angela Arnold and Cornelius Smith met Govan at the Pressure World. They told you that they went to AutoZone for a car cover. Well, the phone extractions say the same thing. There was a receipt from around that time from AutoZone, or at least it looked like it was from AutoZone. Further, Cornelius told you that he wanted his money. He needed his money. And that communication with Juk wasn't really a thing. He would use Govan as the go-between person to contact Juk. But he still needed his money. So he found a way to message Juk, and he told Juk, "What's up, big bruh? I'm trying to get with you. I'm Govan's little homie you met before. I've been trying to let you hear my music if you don't mind giving me a call." Govan's homie. Govan's chosen person for the job. Ladies and gentlemen, we went from this person, this life, to this. You heard from Dr. Sandleberry. 20 gunshot entrance wounds to Adolph Horton's body. We went slide by slide, picture by picture, documenting the injuries that Adolph Thornton received on the day of the homicide. She told you about the manner of death, the cause of death. She went through his injuries, the remote bullets. She told you about the wound on his face. We went from this to this. The defense will try to tell you that the police officers didn't do a good job, that the investigation wasn't complete, but yet they put on an officer as their witness. It seems as if the investigation isn't good if it doesn't cater to Hernandez Govan. It seems as if the investigation isn't complete when it doesn't benefit the defense. You heard from Sergeant Browning that this was a two-part investigation, and that he came and he started to get involved when Angela Arnold talked to officers about Hernandez Govan's involvement. Her interview was December 17, 2021, a month after the murder. It was a month in before they even realized that Hernandez Govan was involved. You also heard that Justin had access to Juk, and that Justin was communicating with other people when he was doing his own thing. But that doesn't take away from this conspiracy. That doesn't mean that this didn't happen. That doesn't mean that Govan is not involved. Govan already had Jip's contact information. He already had Justin Johnson's contact information. He already had Cornelius Smith's contact information. And if you look at the text messages that the defense entered into evidence, you see that there is communication with people that Hernandez Govan also communicates with, like Joshua Taylor. Defense will also tell you that the investigation wasn't complete because there were other people involved that weren't charged. Well, we heard from Sergeant Browning that this investigation is ongoing. By definition, a conspiracy is an ongoing crime that is continuous in nature. And sometimes you just don't have all you need to charge people. Sometimes people die. You can't indict people that aren't here anymore. And if all that isn't enough, you heard from someone that was in the room when it happened. You heard Cornelius Smith. You saw the videos. You heard the testimony of Angela Arnold and Sergeant Browning that support what he's telling you. Defense introduced a video of Cornelius Smith on December 9th, 2021, the day that he got arrested. He told you himself he was a pillhead. He was high. And you saw that in the video. Even Angela Arnold told you that the day that he got arrested, when she was with him, he had taken some pain medication. And ladies and gentlemen, remember the call records. These communications don't lie. They coincided with dates of importance. The week of the turkey drive, August 13th, the shooting on Paper Route Woo. They don't lie, ladies and gentlemen. So let's get into the law one more time. Conspiracy to commit first-degree murder. The defendant entered into an agreement. What is the agreement? What is the agreement? The agreement is if you kill Dolph, you get $100,000. You need one or more people to be a participant in that agreement. You heard from one of them, Cornelius Smith. We know there's Justin Johnson, and there's Hernandez Govan. There is an agreement. And what also do you need? You need an overt act. Earlier I told you that an overt act in the murder case is often the murder. Well, you saw videos of that. You heard the defendant, you heard the shooter, Cornelius Smith, testify that he killed Adolph Thornton Jr. For first-degree murder, it has to be a premeditated killing of another. When we talk about premeditation, we know that there's no timeline on premeditation. It could be months, it could be weeks, it could be days, it could be a few minutes. All you have to do is have time to reflect. All you have to do is have time to think about what you're doing. Well, they had plenty of time. Cornelius said that they talked about this well before this murder. And we saw that the hit on Paper Route Woo was on August 13th. There was plenty of time to think and reflect about this murder. And as you saw from the video, it happened. For criminal responsibility, all you have to do is you have to have an act with the intent to promote or assist the commission of the offense or to benefit in the proceeds or the results of the offense. Smith told you Govan wanted his cut. He wanted $10,000 from Justin Johnson's cut and from Cornelia Smith's cut. That sounds like proceeds. Further, you don't have to be there when the trigger is pulled. You saw the video, you know that Hernandez Govan wasn't there, but that doesn't mean that he is not responsible for ending this life. Ladies and gentlemen, the state's burden is reasonable doubt. You heard in the jury instructions that reasonable doubt means moral certainty. You have to be certain for every element of the offense. That's my job. Certainty means that you can sleep easy at night knowing the decision that you made. It's not beyond a shadow of a doubt. It's not 100% certainty. It's not beyond all doubt. It's beyond a reasonable doubt. That is the standard. Once you've looked and reviewed all of the evidence, all of the photos, all of the videos and testimony that you've heard this week, it is the state's position that we have fulfilled our burden. We ask that you, the jury, make a choice. We ask that you make a choice to hold the defendant, Hernandez Govan, responsible for his actions. We ask that you find him guilty of first-degree murder and conspiracy to commit first-degree murder. Thank you.
We can take a break, Your Honor, just so I can get set up.
How long?
5 minutes, I just have to switch the software over and have the deputies leave my podium.
Let's stand in a brief 5-minute break. They can take a bathroom break.
Court stands in recess for 5 minutes.
No, we're getting ready to take on that. read the jury for me?
Yes, ma'am.
You can go back on your record.
Court is back in session.
Yes.
Jurors entering the courtroom.
Thorough?
Ladies and gentlemen, I want to thank you for your time this past week. You've been stuck in a hotel room with no TV, no internet, just to make sure that your mind doesn't get jaded with regards to anything you see on the press. We talked about first appearances. I also talked to you about the fragility of the criminal justice system, and I hope you can see why now. I don't know anything about the 16 of you, which 12 are going to be the actual jurors. Mr. Govan doesn't know. I don't know if you have kids, if you're rich, if you're poor, if you live in Orange Mountain, if you live in a nice part of Memphis. You see that? I'm from Atlanta. But all I have is trust in you because you said you are peers to Mr. Govan. Mr. Govan, stand up. Come sit at the table and let them see you. It's time you're not marginalized anymore. Sit there while I talk. The fragility of the system is solely based on you. I don't know in what world the prosecution is living in this case, because unless they were watching something in the multiverse where other witnesses were saying perfect things, I don't know why we're here. You all should be embarrassed as a community that your district attorney thinks this evidence is sufficient to take a man's life for first-degree murder. You should be embarrassed that this is the person you voted for that brings this type of case. Just embarrassed. Many of you said you had a problem with the criminal justice system because too many people go free or they get bond. What they don't tell you, what the government doesn't tell you and the press doesn't cover, is this is what happens when you don't have an advocate that knows what the hell they're doing, checks all the records, fights for you, and shows you that he didn't do it. That's just another black man that is of no value from Orange Mountain, that's poor, that has never had a voice in his life. I'm fixing that. My team is fixing that. He is indigent, he is poor, and he deserves better than he's gotten in this case. Sergeant Browning, who's the biggest liar that I'm going to go through with you, says we can't kidnap people and bring them in for questioning. What did Angela Arnold tell you? They threatened to have me arrested, being involved in this case, if I didn't talk to them. We went to the airport and we figured he was going to assert his rights, so okay. What about the second guy, Mr. Sears? His lawyer said he wasn't in town. When you talk about accessories and all this other stuff that the judge has told you about, how about the people that helped hide them? How about the people that helped give him new clothes? How about the people that gave him medical treatment, assuming they were even shot? Because you know what? I don't even know if he was shot, and I don't even know for a fact if that was the Mercedes used in the murder. Because why? There was no blood in the Mercedes. Had there been any blood, to back up what Cornelius was saying, they would have plastered it front and center to you. Their own lieutenant from crime scene that they did not call tells you no one wiped that car with bleach because luminol or the other star thing, whatever it was, would show that. And if somebody said, I poured bleach on a towel and I wiped that car down, they would be lying. I don't know what world we live in. None of you would buy a pack of gum based on the word of Cornelius Smith. You wouldn't do it because he's a lying piece of so-and-so that will do anything. Lie to his pretend grandmother, his family, his girlfriend, anybody. And I'm going to prove it to you as we're going to go through a few more slides. And Detective Browning may even be worse because that's just pure evil, trying to put people in prison based on shaded evidence. Dabney told you the truth, that we didn't do all this other stuff that we should have done. We didn't get around to it, was his quote. He wasn't happy about it, but he told me the truth. The other guy couldn't answer a yes-no question. It was always dodge and deflect, which is what they're taught to do as part of their training when they go and come and testify. These are the people that are policing your streets. You should be ashamed. The only crime that's being committed here today is in this courtroom. It's been committed for the last 3 days. This poor man will never get his life back because of what's happened. He's been threatened because they all think he's involved in the young Dolph murder, and everybody loves Dolph. Dolph has been threatened for years. He moved away from Memphis 5 years ago. He had 3 old bullets in his body from other times he'd been shot at by people, being in Charlotte, being in Los Angeles. Everybody knew there was a price on his head. There is no plan. There is no plan. I tell you why? Because if I made a plan and I go back to my house across the street with the murder car, are you freaking kidding me? And then they go ahead and call around to see where can we go to get changed. We are across the street from the guy that planned the murder. We don't go to his house to change clothes, but we ride around town until somebody picks up the phone, as you see from the records, and we go to 2-lane while we're bleeding and doing everything else. Have you seen a single photo of Angel Arnold's car, the Mercedes, or anything that had a drop of blood in it, as if they said? Cornelius is a pathological liar. I don't even know if he got shot on that day, because you have to ask yourself. There is a bullet lodged in his shoulder, as he told you. For a freaking month, he didn't get infected. He didn't have a problem. He just put some bandages on it, and it was okay. Please, for the love of God, this is insane that I even have to talk to you about this. If this is what is sufficient evidence for first-degree murder, we're all in trouble because you're going to be next. Assault, all these charges they gave you, there's 15 different ways they're trying to convict this guy. I didn't assault anybody. He didn't assault anybody. He didn't aggravated assault anybody. He didn't solicit anybody. He didn't facilitate anybody. He didn't act at whatever ate anybody. It didn't happen. All the text messages, all the phones, everything that showed you. Have you seen one single message from Justin Johnson or Cornelius Smith that says, hey, bro, let's go shoot somebody? I gave you tons of messages over their objection where Justin Johnson is talking to other people, talking about killing people. They weren't discreet about it. Where is a single message to Govan from any of these people over the course of 4 months that says, we're going to do this? Can we get your permission? We're going to give you $10,000 or $38,000 or $50,000 or $100,000 or $1.5 million. You think if they would have had it, they wouldn't have shown it to you? They know the truth is the text messages are only about music because he's friends with Justin. I'm sorry Justin's not a nice guy. They all live in the same neighborhood. They've all known each other. Just because you have, quote, communications doesn't mean you're in a conspiracy to kill someone. Cornelius. Let's go over the slides. This will speak for itself, and I'll let you think about it because I've hammered the point about didn't prove it. I don't need you to say he didn't do it if you don't want to, but they absolutely, for God's sakes, didn't prove it. Let's go to the next slide. All right, so, excuse me. So you see this, what the government says? Angel Arnold's phone? Absolutely. This is Star Defense Exhibit number 1. This C, bruh, assuming C is Cornelius. Send me bruh number so I can get my phone, right? He needs to get his phone. Next slide. Quez's number. Guess what he told you is the one honest thing he said. His brother's freaking name is Marquez Smith. They call him Quez. His brother is the one that got the phone at best. You know why? Because they had TBI Gardner up here. They asked him to do location data analysis on the phone, right? You guys remember all that? And they did it solely for Cornelius' phone, and they did it for Justin's phone. But yet, they didn't show you any location analysis. All they have to do is say, it's in that general area, this is where the tower's pinging, because calls are being made. Where was this call from? Where was his brother Quez? They just BS you constantly, and here I am fighting for this man's life. He is your peer. You need to be here protecting him from this. This is the crime. Next. So I'll just go over a few things on Cornelius Smith. I think that was pretty obvious from his statement. Go ahead, Robert. I think all this is obvious. You got a sociopath on your hands that's out there on his daughter's birthday. Is he intoxicated? Is he not intoxicated? Just ask the prosecutor to tell you a straight answer, honestly. Do you even think the prosecution would take advice from Cornelius Smith on anything? But it's good enough for this poor man's life. My dad used to tell me, you know how somebody's honest? Would you loan them money? Raise your hands if you're going to loan Cornelius money. Because that's the crux of the whole case. And a bunch of BS cell phone records that don't tell you anything. Because they didn't do the location analysis. They can't give you a single text message that says we agree to do anything. And we know it was at least 4 months between the so-called meeting between multiple shootings that Cornelius did and when Justin went out. Next. And if you're not biblical, I'm sorry, but growing up that way, it's just used to be told, the truth never changes. You don't need to remember it. You don't need to practice it. While we're meeting with prosecutors and the lawyer just now report, I don't want a deal. I'm just here out of the goodness of my heart. I'm going to get a mandatory life sentence. Insane. Next. We also showed you the letters from Cornelius that he sent to his sister saying, I've got that lawyer that you paid for. It's this guy's lawyer, and that guy cooperated against somebody else and walked from a murder. That's what you have in black and white in Cornelius' own handwriting. And that is what all of you said when I said, what would you do to avoid a life sentence? You guys said, probably anything. All right. We know this to be true. Next. And we know all this to be true. Next. And we all know this didn't happen. It just didn't happen. His story just didn't happen. And both he and Angela said it. Because, remember, he had talked to his family to go see Angela between the 14th of December, her first statement where she didn't know nothing about nothing, and the 17th of December when she's decided. And note how they have to prompt her to ask, could it be somebody with the name Q? And note, they had to ask her, didn't he forget something? Didn't he tell you something he might have forgotten or something that he needed? They had to prompt her. This is 30 days after that. You don't have to remember the truth. This was the biggest day in somebody's life, you would think. I just killed a dog. I'm running around, and she can't remember who the guy was that picked up the stuff at pressure roll. Oh, shocker. There's a few cameras at pressure roll. They had the absurdity to tell you, well, do you know how long the camera might be working or how long it records? You know how to find that out? Maybe go there and ask them. We've had Ring cameras and other things like that for a decade. It always goes to the cloud, and most likely it's going to be preserved for a year or so, which is what most businesses would do, especially in a dangerous part of town. And guess what? You have those crazy MPD cameras everywhere. You drive home, you'll see them. It's got the little blue thing coming out of it. I've showed you some of those from right around the area. Nobody checked any of them. You don't have to take my word for any of it, because everything I'm going to tell you is going to be backed up by independent evidence. You don't have to trust me for anything. You don't know me. But I want independent proof before I get in bed with a murderer with a machine gun that shot a guy 20 times in broad daylight, and thank God he didn't kill anybody else in that cookie shop. And this is who they're in bed with. Next. All right. Sorry, I just have to calm myself down. The other things with the shenanigans, as they try to tell you, is when the officer accidentally said, I don't even know if it was Justin something, I think he said that, but he said AKA Dolph, I'm sorry, not Dolph, Brock, in that. And Mr. Cornelius says, yeah, I met him through miscellaneous in a moment of weakness. And you know, when I asked about it, how you smiled. You have murdered somebody, and we're up here chuckling. The government's chuckling with him, and he's laughing at me, making smirky faces, and says, I saw you on TV. That's the behavior you want from a guy that took a machine gun and murdered people. In fact, his definition is, I didn't shoot that many people because sometimes we didn't get the shots off or the gun jammed. And you're going to make a deal, not a single text message anywhere, take my word for it. And oh, by the way, I think he's a federal snitch, but I don't know if I believe that or not because he's never snitched on me. All right, next. And then he also tells Uncle Ron, maybe we should have gone and talked to him, whoever Uncle Ron is, but I'm not a policeman, and I'm not trying to put anybody in prison. That there was a bug on him, that he's a snitch, and so you're going to have to plan a big old murder. Next slide. So we know he paid for his lawyer, and we know that was a team issue, and you know the absurdity of the prosecutor in their last statement. They're going to get to go up again and call me every kind of name in the book, which is fine. I can handle it. I will take those arrows for this man that I've grown to care about over the last year and a half because he didn't do it. They had the audacity to tell you we can't indict somebody that's dead. Shook died 2.5 years after all this happened. Remember, Justin Johnson was indicted in December of 2021, about a month after this happened. Cornelius was indicted in January of 2022, about a month and a half after this happened. There is no investigation done in 2023, or essentially 2024. It was done. They indicted and gotten who they wanted. So at some point you gotta ask yourself, what happened here? And I have no idea, but it's not my burden to prove their screw-ups. If you believe Cornelius, he says Jook is the one that set it all up. His girlfriend says that. Then they backtrack and say, well, he was there and he set it up, bingo there. None of it happened. Keep going. And with Miss Arnold, I don't know how you date a murderer that's been domestic violenced me, stolen from me, done this. I don't know what her issues are. I fault her not. She's just doing what the man's telling her to do. They've had visits, they've talked about it, and her story's still iffy as far as that goes. And God bless her. I hope none of you would be with a essentially soon-to-be convicted murderer for 4 years after all this happened. Right, next. And the interesting thing there was, we keep talking about the car on Bradley. Bobby Carter also lives on Bradley, and Bobby Carter was involved in the shootings with Mr. Cornelius. And in fact, Angela says Bobby was involved in the Dunk shooting as well. Next. All right, we already know this as far as the jail calls and the family coming to see her. Next. And we also know about the varying amounts of money this whole thing was worth. So now we get to the meat and potatoes of a few things I want you to consider. Remember, the two pillars to this case is you gotta believe Cornelius Smith, and the judge has told you over and over again, you have to have that agreement, you gotta believe it's out there, otherwise nothing. They've come up with 15 different methods, from murder to second degree to 30, I don't care if it's 47th degree murder, none of this stuff happened. There's no assault, there's no solicitation, there's nothing. So, let's talk about the detectives. Next slide, please. All right, so the Detective Browning, the all-powerful Detective Browning, told you that Govan last talked. Oh, I'm sorry, I got my slides mixed up. We know Dabney, who actually I respect and had a nice talk with. He said they didn't do it straight up. Didn't try to sugarcoat it. We just didn't do it. Didn't go to pressure roll to confirm anything this man was saying. Tells you straight up, we didn't go to AutoZone. Tells you straight up, there was no relevant evidence of AutoZone. So this mystical receipt that's all crumbling, you can't tell what it is. that's supposed to be some kind of evidence now. And they didn't get around to investigating Jook, who was on Team Cornelius or whatever you want to call it. At least he was honest enough to tell you that. Next. So these are the slides you saw yesterday with Detective Browning. And this is where the evil of it all comes in. He did these call detail records for you. And this slide cuts off at 11:16 at 3:01:17. Right? They stopped it right there. I've highlighted for you. That was the slide. You might wonder, Manny, what's the big deal about that? It's just some phone call to somebody, no biggie, right? Yeah, he's talking to Cornelius here, no problem. But guess what? If they would have given you the full story on the slides where they try and bias you, next slide, you see on the same 11:16 at 5:37:15, this is Jook's number, and he spent a 6-minute phone call. It's not on the slide. I had to pull that off the call data records that you're going to have a thumb drive. You will never find it or see it because there's thousands of pages of call information out there. But you see, this thing stops up there at 3 o'clock. They don't tell you this part, that Justin Johnson talked to Jook before the murder and also sent him a turkey emoji. If you are a law enforcement officer, your job is to investigate and the facts go where they may. You don't have a job to convict people. That is why I respect Dabney. He made a mistake, he owned it. Browning is a liar. Pathological liar through and through. Next slide. So I take this where Browning also told you that they last talked to Govan on November 5th. You remember an opening statement that told you Justin Johnson had not talked to Govan for at least 2 weeks prior to the murder. No communication whatsoever. But they try to tell you that, oh yeah, on November 5th, he must have talked to Govan. And then Cornelius last talked to Govan on November 15th. Just remember those. It was very specific that they argued. So let's go to the next slide. So what you'll see is, on November 5th of 2021, this is Govan's number. Hernandez Govan. He's getting a call from Justin Johnson. You see this? This is the communication they had on November 5th. How many seconds is that phone call? Let me break it down to you. Zeros. It never went through. There was no phone call for at least 2 weeks. No text messages. Nothing. And this is the guy I'm supposed to be planning a murder with the most famous person in Memphis. Are you kidding me right now? All right, next slide. So there's an old movie that said, the tail wagging the dog. You've got Cornelius telling him what they want to say as he tells you he likes to do. And everything they're trying to do is back up what Cornelius says. There is no explanation why they didn't go talk to Jook or bring him down for questioning. There's none. There's none. All right, next slide. So just go through here. That's 10, 12 phones out there. Go through all of them. Find me a text message where a single human being tells Hernandez Govan, we need to do something. That's evil, that's violent, that's criminal. Browning told you he just came up with these slides just a day or two before all this happened, because this is 4 years after the fact. And I'm seeing the slides for the first time. And the slides are complete BS, because they keep misleading you about stuff. And so if the incriminating text existed, they would have showed them to you. They've cut off records in half, so you can't see the rest of the story. Go to the next slide. We know he agreed with me that these text messages, there's thousands of them with Justin Johnson. It's about music, because Justin was in videos and all that stuff, and Govan was there. He was a colleague, a friend, whatever you want to call it. That doesn't make you a murder criminal. And we know he talked to Cornelius about pills. 14 communications is what they call it. What they don't tell you is how many of those 14 actually went through. What were the phone call codes? Remember, 11 is important because that goes to voicemail, or it could be two-way, or the call goes through properly. Is it a text message? I don't know. Last night I'm talking to my daughter just about her boyfriend. Between okay, yeah, no problem, I had 16 communications with my daughter in a span of like 3.5 minutes. It doesn't mean anything, and you can't presume you know what the communications are about, if in fact, for the love of God, they even went through. I've already shown you one bald-faced lie by the government right there. There was no call on November 5th. Keep going. So we have the turkey emoji, we have the 6-minute phone call, and you know this secretive plan, PRE, as his bodyguard told you, this is social media. They do this every year. This is what they do. Remember, he's a man of the community. They put it out there. Everybody knows they're doing turkey emojis every year. Most of you probably know about this. Next. All right, skip this. Let's go to the next one. And then we have this. It's not anything I could get voluntarily out of that man. We had to press and press and press to show that Justin Johnson already knew Joe. Didn't need our guy to do any of it. That is why you will never see a single text message of any incriminating nature. Because I can promise you, had it said anything, a comma out of place, they would have it plastered up here on a board saying, see, we got him, we got him. Next. All right, so Garner, he said, MPD asked me to do what? Location analysis on a couple of phones, Justin's and Cornelius's. All you have to do is plug in a number in a computer. We could have done it. Hey, the phone's just pinging off pressure wounds. Maybe more believable. Even if you choose not to go there, you could just ping it. You don't need the actual phone if you've gotten rid of it, because you can just order the CDRs from the phone company, as he told you. He did cell phone tower analysis for a very short amount of time, and then it just stops. Is this the kind of investigation in Memphis we call sufficient to put somebody in prison for life? And none of the other phones were done. Where was Chuck? Hell, where was anybody else in this case? Right? All right, we've got this, so covered that. Go next. We've covered the AutoZone thing, and I just respectfully ask, if the audacity to put a crumply receipt in front of you that you can't read and just say, Detective Brown, I just know this now. It is not mentioned in any police report anywhere. As I asked him, he couldn't answer the question. But now suddenly it shows up in the phone. We know Dabney knew this was garbage because they talked about the auto part from earlier. You can't put a date, time, place on it. It's all what they call red herrings to mislead you. Think there's something nefarious out there and just use your imagination to convict people. You would never let this happen if it was somebody you cared about when you saw this. Some of you might be supervisors. If this half-ass work is what they brought to your desk, you would fire that person immediately. And don't say you wouldn't, because you would, because it makes you look bad. This whole county is a freaking embarrassment with regards to this trial, and the whole world is watching, and this is what we've got. All right, next. And then the last thing is you got to ask, if I set up the plan, I don't know if I'm having the murder car come to my house. And if I am having a murder car come to my house, why don't people just come inside and change clothes there instead of riding around all over town trying to find a place to go change? And again, I know you may think I'm crazy, but there's no blood in that car. Was this even the right Mercedes as far as that goes that they got? You remember Treon Ingram and another gentleman had stolen that Mercedes a while earlier. Treon Ingram didn't come and testify because Treon Ingram picked up another murder right after that. Where did the blood go? Cornelius told you point blank, no ifs, ands, or buts, and your girlfriend, I took bleach and I wiped it down. And the lieutenant from CSI with 28 years of experience says that just didn't happen. Where's Angela's car? Remember, she said he was bleeding all over. Where's the evidence of any of that? All right, next. So all I do is cross my hands and beg you guys, he is your peer. There is no evidence here. You would never accept what's happened in this courtroom in your own personal lives to make any decision of any kind. And he deserves that same respect. There is nothing here. They're going to get to come back up again. Remember, we talked about first impressions. You need to use your minds, your eyes, your ears, and your noses and call the sniff test BS on this whole thing that they're about to give you yet again. There's nothing here. There's no solicitation, there's no facilitation, there's no assault, there's no murder, there's not a text message, there's not a phone call worth a damn, and they aren't telling you the story. Make them tell you, why didn't we investigate you? Make them tell you, why didn't we investigate all the people that helped these folks escape? And if you want to talk about conspiracy, how did he conspire or solicit Justin Johnson? Have you heard anything about that? Who's Jamarcus Johnson? Have you heard a single word out there? They're all together in a conspiracy. All you have is Cornelius' word. He's the linchpin in this whole case, and none of us would trust him. And we sure as hell wouldn't loan him money. And then we have phone records that actually exculpate him. But if you make it all nefarious and have a sleazy detective get up there and talk about it, sounds pretty good. He didn't do it, but you don't have to take my word for it. They didn't prove it. If this case gets a conviction, then I just need to stop being a lawyer because the system is shot to hell. Thank you.
Need to switch to
Are you kidding me right now? Spencer just called the whole city of Memphis stupid and dumb. Everybody from the DA to the police officers to the prosecutors, he called y'all dumb. Called everybody, all one of them dumb. Are you kidding me right now? This case is not about the prosecutor. This case is not about Juke. This case is not about Justin. This case is not about Cornelius. This case is about Hernandez Govan. He is the person on trial, not the city of Memphis, not the DA, not the prosecutors, not you, Hernandez Govan. That's who we are here about today. That's what this proof has been about. Embarrassed. Who should be embarrassed? Hernandez Govan. He is the person that made the choice to get engaged in this conspiracy. He made that choice. We've talked about choices. There are a few things in life that we can control, and our choices are one of them. What choices did Hernandez Govan make? You've heard that over the last few days of the choices that he's made. His choices led us here today. All right, police, they say they didn't do a good job. Convenient story. Something, novel. Because they didn't arrest everybody has to be arrested for them to do a good job. There was a twofold investigation. Sergeant Browning and Sergeant Dabney both told you that. It's very convenient that that part was left out of the defense's argument. There's a twofold investigation. Homicide and MGU. Those are two different entities within the Memphis Police Department. There was an ongoing investigation. And as Ms. Williams mentioned in her closing statements, this is a conspiracy. It's ongoing. To let you know that they were still investigating, look at the call records. Look at when those call records were received. Now, defense will have you believe that, there are thousands and thousands and thousands of pages of call records. There are. But guess what? You'll have access to all of that, and they're on a flash drive. You can search. You can put in the numbers that were given to you. When things happen, what happened with those calls. They're there for you. There's no hiding. There's no putting them aside. They're there for you to look at. So I wanted to clear up that misstatement. The focus at the time of the incident, November 17, 2021, was on a homicide. It was not on who went to AutoZone or who went to Pressure World. The focus was on a homicide. A person was dead. The defense never mentioned that we are talking about a dead person. Dead. It's everybody's issue and fault but Hernandez Govan. The police didn't kill Adolph Thornton. Cornelius and Justin killed Adolph Thornton. But who put them together? Hernandez Govan. Look at the PowerPoint presentation that Sergeant Browning provided. It has communications that contact log was put in there for Juk and Justin on the same day, about July 27th, around that time. They looked like they exchanged numbers. And if they knew each other before then, they wouldn't have had to exchange numbers. They would have already had each other's numbers. Look at that. Look at the call detail records of Cornelius Smith. You'll see about the first time he had contact in his phone anyway with Hernandez Govan was about July 25th, 2021, around that time. All you have to do is plug the numbers in. It's not rocket science, as he'd have you believe. Hernandez Govan put these individuals together. In Govan's investigation, Govan's role in this conspiracy, as far as MPD was investigating, really didn't start until Angela Arnold gave a statement. Now, if we are to believe anything Angela Arnold says, then we are to believe call records, which Sergeant Garner said they don't lie. They're the records. They are what they are. So we can't believe that. We're not supposed to believe Angela either. We're not supposed to believe anything that's happened. The records are what the records are. But they bring in Sergeant Coburn or Lieutenant Coburn. Officers are bad. They don't do a good job. But he wants you to, well, this officer did a great job. Just this one that we bring in. He did a great job. Cornelius will tell you, he didn't just get a whole thing of Clorox and pour it all over the car and wipe it down. He said he sprayed some substance on a towel and wiped. He was still hurt. It was in the dark. He was in a rush. He was scared probably that Govan was going to come out and shoot him or do something because he was across the street from his house. But you want us to, defense wants you to believe that all the officers are bad, they did everything wrong, except that part. The investigation was ongoing. Look at the call records. Look at when they were done. And you can still investigate. And because you want someone arrested tomorrow, it doesn't mean the evidence is all there. At this point, Juk is dead. Bobby Carter's dead. Joshua Taylor's dead. We can't arrest them. We're not digging them up from the ground. They are dead. That point is dead. Browning just analyzed the numbers that were there. Garner said the records are what they are. They come from the phone company or from the phone. All Browning did was analyze it. To say, hey, these many calls came from this individual, this many contacts. That's all Browning was brought here to testify about. But because those records show Hernandez Govan communicating with the conspirators throughout the summer, throughout the fall, from July until November, well past November 17th, at least November 20th of 2021, oh, Browning's a liar too. And when all he did was analyze the records. The records were made by Mr. Govan. Defense also brought up that basically Justin Johnson had access to Juke on his own, basically. But we know that Govan made that connection. July 27, 2021. We know that. We see that in the call records. We see it. Govan already had Juke's information. Govan already had Justin's information. This was by July 27, 2021. Govan had Cornelius' information. Govan texts Justin address to Juke's smoke shop. And the contact was created between the two while they were there. But guess who did not have contact with Juke? Cornelius. He was a part of this conspiracy as well. And he got up here and he testified. And he told you that he really didn't have much contact with Juke. Guess who he was communicating with? Hernandez Govan. That's who he was communicating with. And let's look at the definition of conspiracy. You just have to create that at least with just one other person. So if you take defense at his word that Justin Johnson had other conspiracies going on and this was something separate, Hernandez Govan was still egging on Cornelius. He promised to get Cornelius paid. Cornelius didn't have direct access to Juke. He told you he was trying to still get his money. December 2nd, 2021, he sent a message from Angela Arnold's phone via Instagram messaging. He said he couldn't just straight out put that, hey man, I want my money. I did what I was supposed to do. He said he sent him a message trying to get his attention. A week later, he's arrested. But Hernandez Govan was the link between all of them. Hernandez knew Juke. Even if the order, if it did, that's still being investigated. But if the entire hit came from Juke, it was communicated to Govan, who then put it out to Justin and Cornelius. Hernandez Govan did that. The defense also makes the assertion that for 2 weeks, Hernandez Govan didn't have any kind of contact with any of the people who did the killing. He didn't have contact with Cornelius. He didn't have contact with Justin. The phone records will tell you that that is not true. It's simply not true. The phone records are there. There was contact. There was contact the day before. There was contact the day before that. There was contact days before that. And even if they didn't talk on the phone, what is stopping them from walking to his house? Communication is there. Doing everything to take away from the fact that this trial was about Hernandez Govan. And there's nothing that says, okay, if we don't talk within 2 weeks, that all of this is out the window. Nothing in the jury instructions that the judge gave you or read to you said, all right, this conspiracy ends if we don't talk in a week. This is not girlfriend and boyfriend stuff. This conspiracy was ongoing. Hernandez Govan is just trying to pull himself away at this point. But this, Justin and Cornelius, they were put together by Govan. It's been reiterated several times. All right, even if you believe what the defense says, say Justin was conspiring with others. Okay, two things could be true at the same time. But what we do know that shortly before the turkey drive, Cornelius said that Hernandez Govan called him and Justin together and was like, hey, y'all know this turkey drive getting ready to come up. Y'all ready? Y'all ready to make this money? Y'all ready to do this? Cornelius told us that. The call records, they show that there was some communication shortly before the turkey drive, the week before Thanksgiving. And Govan just reminded them, this is your mission. This is what you're supposed to do. If you want this bread, you need to make it happen. You need to make sure that you take care of that family that's been out there. You need to make sure this is what you do. So Justin chose, even if there were other conspiracies, just if there were other conspiracies on the side. On November 16, 2021, Justin Johnson chose Cornelius. He chose Cornelius. The same Cornelius that he was introduced to through Hernandez Govan. That same day, Justin Johnson sent Juke a turkey text. It's the same text that defense has entered into evidence. He sent that on November 16th. The defense just showed you there was some communication with Juke on November 16th. On November 17th, again, the day of the murder, the day that Dolph was killed. Even if there were, again, other conspiracies, Justin Johnson chose Cornelius Smith to go on a hunt with him. He chose to go on a hunt with him. He chose him the day before. He chose him on the day of. And Cornelius Smith said the only way he knew who Justin Johnson was because of Hernandez Govan. He told you that several times. Then we talk about Cornelius. Let's talk about his testimony. Cornelius was the state's witness. Prosecutors are probably not going to be hard in screaming at their own witnesses. The point is to get the witness to talk so that you, the jury, can understand what's going on. They're a witness. Cornelius, at this point, has already testified in a previous trial. He has no reason to come in here and lie to you about what he did. He said and told you, as you watched the video of the murder of Adolph Thornton, he told you, that's me with the big gun that killed him. Now, if any part of that is, if he's to lie about, why lie about him killing somebody? That's where you lie at. He didn't lie about that. He told you. I did. But I wouldn't have known Justin Johnson except for Hernandez Govan. And he put us together to get this done. He told you, the defense attorney, at least several times, that he was under the influence. You saw the video. Cornelius Smith was up there. He was high. Even the questions that were asked of him were confusing. And he told you, he said, I don't remember. I had taken some pills, and we learned he'd been taking pills. So why at that point say anything different? Even Angela Arnold said he took some pills that day. Yeah, he may have been fine, but he told you. I've been doing this for a long time. It may not affect me the same way that it affects someone who doesn't take pills. But in addition to the pills he was taking, he took some Tylenol PM. Defense tried to make it seem like it was just, a headache medicine. But he was getting that edge. He saw the end of the road coming for him. He knew the marshals were behind him. He knew that. He's taking them pills. So they tried to get a statement out of him that day. He's all over the place. He's confused. Doesn't really say much then. But he gives a statement eventually. And he tells you on the stand what happened. How Mr. Hernandez Govan set all of this in motion. And defense, paints him as a liar. Cornelius said his game with the women. Well, Angela, she's still with him. Some kind of game. Letitia Jackson, his kid's mother, he had enough game where she took his phone. He handed over his phone to her the day he got arrested. And Miss Ferguson, the neighbor, she said, he's a sweet baby, just sweet as he won't be. Just look. He helped her out. She didn't have a bad thing to say about him. Said he didn't give her $500, or someone didn't give him $500 for Cornelius. How do we know Miss Ferguson is the neighbor that happened to? Live on the street, there's several neighbors. But he brings sweet little Miss Ferguson in. We had nothing bad to say about Cornelius. Cornelius, this testimony was backed up by Angela, by the evidence and phone records, by the murder. All of that is backed up. Okay, you have looks like an AutoZone receipt in a picture of it, crumbled up. You have access to the picture of their receipt. It was a picture that was in the phone that Cornelius took. It was in Browning's presentation. Look at the receipt. Blow it up. Stretch it out. You'll see that was taken, it looks like AutoZone, and it was a receipt from November 20th, 2021. In the end, all of this points back to Hernandez Govan. He got the ball rolling. He kept the ball rolling. He kicked the ball in the end. He introduced Cornelius Smith and Justin Johnson for the purpose of taking out members of PRE. One member of PRE being Adolph Thornton. That's where the conspiracy started. Again, all fingers point back to Hernandez Govan. Justin, Hernandez Govan. Cornelius, Hernandez Govan. Juke, as the defense keeps wanting to throw out, Hernandez Govan. And why go to Hernandez Govan house after they commit the murder? Because that was comfortable for them. No one ever said these were the smartest killers. They didn't plan on getting shot. That wasn't part of the conspiracy. When we get shot, we're going to go here. But they'd already had the getaway car at Hernandez Govan house. So they originally met at Hernandez Govan house back in July. If they would ever meet up during the time of the conspiracy, from June of 2021 until March or whenever they were arrested, they would meet at Hernandez Govan's house. Want to go shoot a video? Go to Hernandez Govan's house. They're all in the video. Park your getaway vehicle? Go to Hernandez Govan's house. Park your murder vehicle? Hernandez Govan, that's the person. Now, why did they not go in? Maybe he wasn't there right then. Maybe he was like, someone went down, I'm getting out. Who knows? But we know what happened. We know where they went. We know that the murder vehicle was parked there. We know that the getaway truck that they used to get somewhere else was parked in front of Govan's house. We know that. Even Cornelius Smith told you, Cornelius Smith told you that Justin wanted him to meet him on the day of the murder. He wanted him to meet at Govan's house. Cornelius said he couldn't get over there. So Justin came and picked him up. Again, all of this going back to Hernandez Govan. As much as the defense tried to deflect and get you to choose different deflections, it all points back to Hernandez Govan. Hernandez Govan had choices. He chose to bring Cornelius and Justin together. He chose to encourage them to have a hunt, to go on a hunt. PRE members, but the biggest bounty was Dolph. He knew that Cornelius had a drug habit and that he needed money. And he played upon that. He preyed upon that. And he put him together with someone who was just as hungry for him. Justin and Cornelius were put together by Hernandez Govan. He chose to ask each of them for a cut of the proceeds. He chose conspiracy. Hernandez Govan chose murder. Adolph Thornton will never get to experience many of the things we take for granted in getting old. He will never get to experience gray hair. He will never get to experience wrinkled skin or crackling knees. He didn't get to choose to grow old. That was taken from him and put in motion by Hernandez Govan. You, the jury, you have a choice. The choice is now yours. You have a choice in whether you hold Hernandez Govan accountable for his role in this murder, for his role in this conspiracy. And I ask that you choose to find Hernandez Govan guilty of murder in the first degree and guilty of conspiracy. Thank you.
All right, ladies and gentlemen, I'm picking up on page 27. Deliberation, order of consideration. In reaching your verdict, you shall first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. Verdict. Count 1. The charged offense in the first count of the indictment is conspiracy to commit first-degree murder. The lesser included offenses in order of consideration from greatest to least are facilitation to wit, conspiracy to commit first-degree murder, solicitation to wit, conspiracy to commit first-degree murder, and accessory after the fact to wit, first-degree murder. Count 2. The charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, solicitation to wit, first-degree murder, solicitation to wit, second-degree murder, aggravated assault, facilitation to wit, aggravated assault, accessory after the fact to wit, first-degree murder, assault. Count 1. When you retire to consider your verdicts, you will first inquire whether the defendant is guilty of conspiracy to commit first-degree murder, as charged in count 1 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of conspiracy to commit first-degree murder, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of facilitation to wit, conspiracy to commit first-degree murder, as embraced and included in count 1 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of facilitation to wit, conspiracy to commit first-degree murder, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least. If you find the defendant is guilty of a lesser included offense, your verdict will be: we, the jury, find the defendant guilty of, placing that offense in that blank, embraced and included in count 1 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 1 of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be: we, the jury, found the defendant not guilty as to count 1. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. Count 2. You will next inquire whether the defendant is guilty of first-degree murder as charged in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of second-degree murder as charged and included in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of second-degree murder, including and embracing count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least. If you find the defendant is guilty of a lesser included offense, your verdict will be: we, the jury, find the defendant guilty of, placing that offense in that blank, embracing included in count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 2 of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be: we, the jury, find the defendant not guilty of count 2 of the indictment. Check the corresponding box on the verdict form and sign one of your names to the verdict as foreperson. When you retire to the jury room, you will first select one of your members as foreperson who will preside over the deliberations. When you have reached a verdict on a particular count, the foreperson will check the corresponding box on the verdict form and sign his or her name to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and return to the court with verdicts that truth dictate and justice demand. Now, there is a couple things you need to know. Pages 33, 34, and 35 are your verdict forms. So I kept referring to check the corresponding box. These are the corresponding boxes. You got count 1 and 2 pages for count 2. Okay? I also have here the official copy of the jury charge. There are a couple of minor changes that I've made, like I caught one misspelled word, a couple of misspelled words, and I've made those changes on here. Nothing that's going to change it substantively. But the official copy is going to go back to the back. Please do not write on it. Feel free to write on your own copy. Just use this as the official copy if there's any discrepancy on what you may have with you. Okay, so this is the official copy. So is everybody in a good position to deliberate? No issues with the court we know about? All right, so we shall choose 4 alternates. Once again, all of the exhibits are going back to the back with you. You will be provided a computer, a blank computer that you can use to look at any of those zip drives if you'd like. Miss Stacy, do you have anything back in the back you need to collect? No. If you'll just stay right where you are, please. Ms. Wilkes, ma'am, do you have anything back in the back? Mr. Cobb, do you have anything back in the back?
Just a book.
You want to go ahead now? Mr. Ayers, do you have anything back in the back? Yes, sir, right there. All right. You want to go collect? If you have any questions, please write them down and turn on the light. And, Officer Parks will come collect the questions. George, you are excused to deliberate. Officers, stay in front. All right, please stand in recess.
I'll sign a brief receipt.
Oh, it's just so lawyers this. I
I
had
have
a
no
bad
idea who that
experience
is.
one time, so I always show lawyers what the numbers are, make sure we aren't playing with the numbers, so. All right. question is, what is a proper statement? What does it entail? What are the details and what does it specifically protect? I don't think I can answer this.
I don't think we can.
Yeah.
Okay.
Because we didn't, none of that was, I mean, some of it was in the proof, but we
Yeah,
didn't
well,
give
it's-
any evidence. And,
Cornelius talked about it, but I understand.
Oh.
We talked about it with his lawyers, all that stuff, you know, proper protections that you can't be charged. And he said, yeah.
okay.
Could we just say it's a protected statement of police?
No. You can't say that. Even though it's kind of the truth, it is the truth, but no. I have to be very careful with, I mean, that's almost putting evidence in without, you know, without it coming from the stand. I have to be very careful when I answer, when I define things and things like that.
And I guess we can't answer it.
Yeah, I can't answer it. So I will respond. The court can't answer these questions. I could go ahead and say, that would be, admitting evidence without a witness to do so, or I can just say I can't respond and be done.
Okay.
Yeah, they're not gonna like it, but they'll be all right. We can come off the record.
Court's back in recess.